One of the trademark topics that over the years we've really become masters at dealing with is likelihood of confusion refusals from the US Patent and Trademark Office. Of course, no one wants to get a refusal, but even when an application is filed by an attorney, there still are circumstances where an examiner may issue an office action finding a likelihood of confusion with one or more registered trademarks. I want to talk today about 3 different potential ways to overcome a likelihood of confusion, or as it's known, 2D refusal. The first and most common way is to submit arguments in an office action response to the examiner. A response with arguments might talk about the different meanings of the marks or the different spellings or wordings in the 2 marks. It might talk about how elements that are shared between the marks could be diluted or weaker. Or another type of common argument would be focusing on the goods or services of the applicant and the registrant and how related or unrelated they are. So those are some of the different types of common arguments that are made in addressing a likelihood of confusion refusal. But the second type of way to possibly overcome or get around a 2D refusal is to get consent from the registrant. Now, this doesn't come up as often because you generally only want to approach a registrant if you're sure that you have priority. And priority can be complicated, and knowing whether or not you have priority can be complicated. And there are always risks of contacting another party. But sometimes that's the best option if the facts are in the applicant's favor. But you want to examine the pros and cons. You want to examine what incentive the party you're contacting may or may not have to cooperate. And an important factor in this possibility is that the examination by the USPTO examiner doesn't always live in the real world. And in the real world, the parties may agree that there's no confusion, where an examiner may be bound by what's in the records and may, be convinced that there is a likelihood of confusion. So that's the second type of way, is to get consent. The third type of way to address or overcome a 2D likelihood of confusion is to potentially cancel the cited registration. Now, sometimes the cited registration will become canceled on its own during the process. That would generally be if it's up for renewal and it's not renewed. So one important thing to consider is, what are the dates at issue? When is a response due? When is the registration up for renewal? Is there some opportunity to possibly wait and see if the registration becomes canceled or abandoned on its own? But if that's not an option, and if the facts and circumstances are appropriate, again, this generally comes back to priority, it may be possible to petition for cancellation or expungement of a cited registration, and essentially then remove the obstacle itself. Essentially, you're no longer trying to coexist with or get around the obstacle, you're trying to remove the obstacle. So if you look at these 3 ways, the first, arguing, is trying to get around the obstacle. The second, consent, is trying to coexist with the obstacle. And the third, cancellation, is trying to remove the obstacle, the cited registration. These are the 3 main ways that applicants may be able to address and deal with a 2D likelihood of confusion from the US Patent and Trademark Office. If you've received an office action and have a specific issue you'd like to discuss and see if we may be able to help you, you can always reach us at info@ericpelton.com or visit ericpelton.com and see the Connect with Us button in the top right corner.